Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On October 6, 2020, the Supreme Court heard oral arguments regarding Tanzin versus Tanvir, a case involving the Religious Freedom Restoration Act of 1993, commonly referred to as RFRA. The issue in this case is whether RFRA permits suits seeking money damages against individual federal employees. To discuss this case's oral arguments, we have Stephanie Taub, Senior Counsel at the First Liberty Institute.
My name is Stephanie Taub, and I am Senior Counsel at First Liberty Institute. First Liberty is a nationwide law firm dedicated to defending religious liberty for all Americans. So as he mentioned, today we're here to talk about Tanzin v. Tanvir, a religious liberty case that was heard by the Supreme Court yesterday morning. My firm filed an amicus brief in the case in support of the plaintiff's respondents. Okay, so what was the issue in the case? The question before the court is whether the Religious Freedom Restoration Act, or RFRA, authorizes claims for damages against federal officials who are sued in their personal capacities. As I'm sure you all know, RFRA or the Religious Freedom Restoration Act, is one of the main religious freedom laws used over the past few decades to prevent the federal government from infringing on religious liberty. It specifically provides a cause of action for people whose religious exercise has been burdened. So this case is a statutory interpretation case, and it turns on how to properly interpret the RFRA statute, and specifically its remedies provision. So we're going to look at the text of RFRA, of that remedies provision. It allows lawsuits to, quote, obtain appropriate relief against a government. So the question is, what does that mean? And RFRA defines government as including, quote, a branch, department, agency, instrumentality, and official or other person acting under color of law. And that last portion is in a parenthetical. So putting those together, the question for this case is how to interpret the relevant terms appropriate relief against an official or other person acting under color of law. The statute doesn't specifically mention damages or injunctive relief one way or the other. And the parties are agreed that appropriate relief at least includes injunctive relief, and they disagree about whether it also includes damages under any circumstances. So at a 10,000-foot view of the arguments, on the one hand, you have the religious plaintiffs who argue that there is a general presumption in the law that when you have when a statute calls for appropriate relief, that includes all available relief, including damages, unless that form of relief is barred by something like sovereign immunity. And then the plaintiff respondents also argue that the statute must be read in light of the broad purpose of RFRA, which was to strengthen religious freedom protections and provide broad relief. On the other hand, you have the government arguments, and the government argues that the purpose of RFRA was to provide relief against a government. They focus on the phrase against a government, and they argue that that shouldn't be read to encompass personal capacity suits against individual government employees. The government wants to create a presumption that the personal capacity suits aren't authorized unless there is a clear affirmative statement in the statute. So because damages aren't mentioned, does that cut in favor of a presumption one way or the other? How should it be interpreted? That's the main issue in the case. So stepping back, let's take a look at the facts and upon which this case comes to the court. So this case involves 3 Muslim men who are U.S. citizens or lawful permanent residents. They allege that they were approached by FBI agents and asked to act as informants against their religious community, which would violate their religious beliefs. So they alleged that they were placed in a difficult position where they, and when they refused, they were wrongly placed, they alleged that they were wrongly placed on the no-fly list in retaliation for refusing to act as informants and barred from taking commercial flights. So essentially, they're placed in a difficult position where they're either forced to act as informants against their community or be barred from flying on commercial flights. And so they brought a lawsuit in New York that included several causes of action, including causes of action under RFRA. They sought injunctive relief to be removed from the no-fly list so that they would be able to fly again. And they also sought damages to recover the amount they lost for plane tickets and other economic damages. One of the plaintiffs had to quit his job, for example, because that job involved regularly taking commercial flights. So after they filed their lawsuit, they were subsequently removed from the no-fly list, so they were able to move again. And that mooted their claim for injunctive relief and leaving only a potential claim for damages. And so one of the main themes in this case is if you no longer have injunctive relief and the only potential relief you have for violations of RFRA, for infringements on your religious belief, is a potential damages claim, if the government is able to simply moot the claims for injunctive relief, they may never be held accountable for violating religious freedom. So here, when you have a situation where a plaintiff's rights were violated in the past in some sort of or if you have someone whose rights were violated in a one-time incident, they wouldn't be able to be made whole if damages relief isn't available. Then next, so now the federal government is appealing this issue to the Supreme Court. So the only thing at issue here is whether RFRA, the Religious Freedom Restoration Act, authorizes personal capacity damages lawsuits against federal officials. Okay, and before we turn more specifically to the parties' main arguments, it'd be helpful to take a step back and quickly go over the history of RFRA. This may be a refresher course for most of you, but just bear with me and put it in helpful context for interpreting the statute. So in 1990, the Supreme Court issued a landmark opinion in Employment Division versus Smith, written by Justice Scalia. It created a major shift in constitutional law, severely constraining what kind of religious freedom cases can be brought. Smith essentially shielded neutral and generally applicable laws from free exercise challenges. So it didn't matter if a law happened to burden your religious beliefs or put you in a position where you're forced to act against your religious convictions. Previously, under pre-Smith law, if a law did burden your religious beliefs, you could go to court and seek relief, and the government would have the burden of proof, and the courts would apply some form of heightened scrutiny to your claim. And so Smith was widely seen to have gutted free exercise protections from the Constitution, especially at the expense of religious minorities who might not have the political influence of other groups. So in the wake of Smith, there was really this bipartisan outrage from both the left and the right. And in the wake of that, RFRA was passed with nearly unanimous support from Congress, and it was signed into law by President Clinton in 1993. And the intent of RFRA was to restore religious freedom law to what it was before Smith, and to provide for very robust enforcement of religious liberty protections. So Congress wanted RFRA to apply to both the states and the federal government, but the Supreme Court in the city of Bernie v. Flores said you can't do that. You'd need a constitutional amendment if you're going to reinterpret the First Amendment. But you can bind the federal government. So RFRA applies only to the federal government and not to the states. And in response, Congress created a more narrow statute to protect religious freedom in two specific contexts. And that statute is the Religious Land Use and Institutionalized Persons Act, and that is otherwise known as RLUIPA. And so now with that background, we can turn to the government's main argument. So the government is relying on, the main case that they rely on is a RLUIPA case. So this is RFRA's sister statute, the Religious Land Use and Institutionalized Persons Act. In 2011, the court took a case called Sossaman v. Texas, which looks at the remedies provision of RLUIPA. And so here we're looking at the remedies provision of RFRA. And so in the two statutes, if you take a look at them, they have very similar language. They have very similar purpose. They're considered to be sister statutes. So they're both construing what does it appropriate relief against a government mean. And in Sossaman v. Texas, the majority of the court decided that appropriate relief against a government did not include damages against the states. So the government now argues that RFRA should be interpreted in the same way. But the respondents here argue that Sossaman doesn't necessarily affect the outcome because that case turned on sovereign immunity. If you read it, it's all about sovereign immunity. So here, there are no sovereign immunity concerns. Of course, if you're talking about officials sued in their personal capacity, they're not entitled to sovereign immunity. Whereas in Sossaman, the court was considering sovereign immunity with respect to Texas, the states, who do have sovereign immunity. So when you're looking at the phrase, you have to, through the lens of sovereign immunity, the analysis is different. States are not construed to have waived sovereign immunity in a particular context unless the statute is clear enough to put the states on notice that they're waiving that sovereign immunity. So in Sossaman, the court held that the phrase, if there's any ambiguity in the phrase, or that it wasn't clear enough that damages against the states were authorized in light of presumptions in play due to sovereign immunity. So that's the main case that the government relies on. And then the respondents, the main case that they're relying on is they think there should be an opposite presumption, that they're relying on Franklin v. Gwinnett County Public Schools. That case establishes the presumption that appropriate relief includes damages unless otherwise specified. So the general rule of remedies is that courts are entitled to fashion appropriate relief, and damages are usually included in that. So the government responds that Franklin doesn't apply here because Franklin was interpreting an implied cause of action, not an express cause of action. It was a very strange situation where the court found an implied right of action in Title IX. There wasn't any sort of statutory language about the private right of action or any remedies provision that the court was interpreting. So the government says Franklin only applies in that now disfavored situation, an unusual situation where the court is interpreting an implied cause of action and doesn't actually have statutory language to look at. So those are kind of the two main cases that are relied on in this case. So then there are a few other arguments that are raised. And so let's take a look at the oral arguments yesterday and some of the interesting questions that the justices asked. So first of all, some of the justices, Alito, Gorsuch, Roberts, focused in on the language of one of the terms in the definition of who counts as a government actor who can be sued. So RFRA lists what counts as the definition of government as including, quote, another person acting under color of law. And that language is included in a parenthetical right after the term official. And so the question is, so who is this person and what remedies are available for this person? So this seems to authorize lawsuits against some private individuals who aren't government employees, such as some private government contractors. Both sides concede that this language applies to some private government contractors, and such as private individuals who run a prison, for example. And so respondents point out that there is no such thing as an official capacity suit for a private person. So the only available relief against these individuals would be damages. But the government took the position that RFRA doesn't authorize damages at all, even for this private person. So the government's position is, no damages at all, even for a private person. And that the statute only authorizes injunctive relief even against a private actor. And this seems to be a surprising position to at least Justice Gorsuch. There's a very interesting exchange that happened in the oral argument. He pushed back on this point. Gorsuch asked why the government thought that only injunctive relief was authorized, and whether what their justification was that, whether their argument turns on the word appropriate in the phrase appropriate relief, or whether it turns, rather than the definition of who can be sued, who counts as a government actor. And the government responded that both inform their argument, that the definition of who is a government actor also informs the decision, because that emphasizes that the relief needs to be against a government. And they emphasize over and over again the phrase against a government. But Gorsuch responds, the definitional section doesn't speak to the nature of relief at all. And then after a little bit of pushback, the government says, well, not in so many words. And Gorsuch says, so it does turn on the phrase appropriate relief. With the merger of law and equity some time ago, that's a quote, courts have been allowed to provide any kind of relief available appropriate to the circumstances. So that's an interesting exchange, which may show what issues Justice Gorsuch is grappling with respect to his form of textualism. I think Alito and Roberts also asked about how that parenthetical person acting under color of law interacts with their statutory interpretation arguments. Then on the other hand, we have Thomas and Kavanaugh, who both brought up the issue of mens rea. They are concerned with the prospect of federal officials facing personal capacity lawsuits for something that they did unintentionally. So maybe you have the FBI agents, and maybe they're unaware that they are incidentally burdening religious free exercise rights. Because if you look at RFRA, it was designed to go beyond Smith or pre-Smith to prohibit government from even incidentally placing a burden on a person's sincerely held religious beliefs on their free exercise. And so Thomas asks, is there a mens rea requirement in this case? Do you need to intentionally burden free exercise rights in order for a lawsuit to be brought? And so the respondents say that RFRA only requires the burden is substantial. There isn't any sort of, there isn't an intentional requirement. That in this case, under the facts of these circumstances, facts of the case, they believe that the agents knew or should have known that what they were doing was burdening religious freedom of the plaintiffs. And so Thomas asks a reasonable question: how would a person know that a burden is a least restrictive means of fulfilling a compelling government interest? How would that government employee know that? And so the respondents would say these are the kinds of questions that would be decided on remand. And in particular, under the qualified immunity standard. So the respondents overall, they argue that qualified immunity is a very high bar. It will shield most government employees. So unless these employees are plainly incompetent and flouting clearly established law, qualified immunity will operate to protect them. And these issues can be worked out on remand through qualified immunity. So here, when we're talking about liability available against federal officers in their personal or individual capacities, we're really talking about those federal officers that are acting in such an outrageous way in disregard of religious freedom, such that they could overcome qualified immunity. So we're not talking about the standard government official that maybe happens to make a mistake and incidentally infringes on religious freedom. So qualified immunity is a high bar that should take into account those sorts of concerns. And then we have Justice Kagan asked some very interesting questions. One of her questions, she was talking about pushing back on the government's interpretation that RFRA was not designed to authorize any sort of damages relief. She said, well, before City of Bernie, Congress wanted RFRA to apply to the states. And prior to Smith, damages were available against state employees in their personal capacity under 1983. So she asked, did Congress intend to create fewer remedies against state and local officials than pre-Smith law did by intending to take away all available damages? Which seems to be a little bit odd if we have the whole point of RFRA was to expand protection for religious liberty, and the government is saying that this provision contracted it and took away what was what would have been damages remedies under 1983. So the response that the government gave was that we're focusing on, so the purpose of RFRA was to reinstitute a different substantive standard and not necessarily incorporate all of the same remedies that were pre-Smith. And finally, turning to Sotomayor and Breyer, Justice Sotomayor brought up legislative history. So she said that RFRA, if you look at what Congress was discussing when RFRA was passed, they were concerned about families whose loved ones were subject to autopsies against their religious beliefs. So in circumstances like that, the damage is done, injunctive relief isn't available, and it wouldn't help those families. So the only potential for relief in circumstances like that is damages. And there was testimony about these sorts of circumstances that Congress was considering when it was enacting RFRA. And so the overall thrust is to give a cause of action, a claim, and a remedy for people in this sort of a circumstance. And so she asked why Congress would take away the only relief that could help some people. And so Sotomayor's question really reiterates her position in Sossaman. So Sotomayor and Breyer were dissenting in Sossaman, and Sotomayor wrote the dissenting opinion. And they argued that RLUIPA available relief under RLUIPA did include damages, and they thought it was so clear that it should have pierced sovereign immunity in that case. So I think if we were to wager on what Sotomayor and Breyer would do in this case, based on that Sossaman dissent and their questions here, I think it's pretty. They might be the easiest ones to guess on where they might come out in this case. So they probably are likely to reiterate their points from the Sossaman dissent that appropriate relief generally does authorize damages for claims like this. And then I think, so what else might happen? Where might the others fall? I think Thomas and Kavanaugh, from their questions today, were clearly, or more clearly on leaning toward the other side with their concern about the mens rea requirement for federal officials. And so they may lean that way. And the others, it's not clear which way they will break. This case does have the potential for an unusual coalition, with Sotomayor and Breyer being in favor of stronger religious liberty protections, and so it's possible that we could get some sort of an unusual combination of justices here. And so it'll be really interesting to see which way it does come out.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.